So the Constitution requires ordered liberty, which is to say we always take into account the public interest, and it's not enough just to ask the question of whether or not the religious believer needs the protection. That's where the Constitution leaves the question. It says that the rule of law applies to religious entities just as it applies to everybody else. But as many of you, I'm sure, are familiar, there are many laws in this country that give special treatment to religious entities. They provide what is called accommodation. So, for example, in a number of states, there's a rule that says that if your child is ill and you do not provide necessary medical treatment, that's neglect, that's parental neglect. Those same states also might have a rule that says, but if your neglect is prompted by faith, so that it's faith healing that you're engaging in, and that's why the child is not getting medical treatment, you might be immune from either civil or criminal prosecution. That's the kind of exemption that has exploded in the last 10 to 20 years, and we have reached a point where there are literally thousands of accommodations or special treatment for religious entities in both state and federal law. One example is the faith healing example I just gave you. Another example would be the rule in the military that you can wear religious headgear if you are engaged in activity other than direct combat. There was a time when the military didn't let you do that. You had to wear their headgear or no headgear. But Congress decided that was silly. A man who was a rabbi brought, a man who is a Jew brought this claim and said, wait a minute, I'm wearing a yarmulke, it's not getting in anybody's way, why can't I wear it in the office? The Supreme Court said, you don't have a constitutional right to be able to wear the yarmulke. And then Congress said, but you have the statutory power to do it. So what we have is a system in which the Constitution prevents discrimination, but these greater privileges are coming from state and federal legislature. This has become, because of the doctrine at the Supreme Court, this has become the issue in the United States right now. It is being hotly debated both by scholars and in the public press. It is the issue that is working its way through both the state and federal courts and will be up to the Supreme Court in the near future. And the question is this: how far can the legislature go if what it wants to do is to accommodate religion? For example, can a legislature say that if you are a religious landowner, you have special privileges to avoid zoning laws, whereas every other landowner in the same community has to abide by every zoning law? So if you want to have a 300,000 square foot building in a part of the city where it's not zoned for such a building, do you get that right just because you're religious? Those are the kinds of questions that are percolating in the lower courts right now. And the hard question that the court has not begun to answer is not only is it okay to accommodate religion, it is okay to accommodate religion, but when does the accommodation go too far? And that's the issue we're going to see in the near future, and that's when the free exercise of religion turns into a question about the separation of church and state.